A couple of you could mention in the chat if you can hear us. Yep. All right. Perfect.
All right. So we're doing this today, in the first opportunity to sort of let you know where we're at and what's happening and where we hope to go. The second part of this is if you take the opportunities to put any questions in the chat, we'll take the questions from there and we'll send them to the legal team. Regretfully, we had asked legal to be here for this meeting, but they're too busy, apparently. So they're doing what they need to get done, and we're going to try to resolve as many of your concerns that we can. So let me start with, in the first instance, we have, for want of a better term, groups that are further advanced along the disciplinary trail than aviation as a whole. You're just starting to catch up with other groups in respect to that. So the path is a little bit, we understand the path a little bit more than you guys will right now, in that you will start to see us generate more letters on your behalf in the next short period of time as your employers start to become more decisive in their decision-making processes. Some of you in some airlines such as Alliance or Rex, for want of a better word, and some of the smaller groups may have started to see some of those more directive letters coming from us, but through our legal team. So that's where we're sort of sitting in regards to that. I know a lot of you are very anxious about that the time's approaching, if not as fast, that you're looking at your medicals and they're not being approved. And we've got, when you're sending us that stuff back through the supporter line, we have a group of people who are gleaning through that process and taking those indicating notes out. So if you're sending back a note saying my medical request or my medical exemption was denied, there's a group of people out there that are just looking for them. They grab that and they shuffle that off to one section in the legal department, and they look at writing responses for them, and that gets gleaned into the further process that will go down the track. So to help you better understand, I hope, is that we started with a workplace health and safety issue. And as you see us progress, you'll see us define that at each stage now through the lawyers, so that we end up essentially having a fight with your employers, or a dispute with your employers, more about breaches of the Fair Work Act and more about breaches of health and safety than actually about the COVID vaccine. So that's the direction that we will end up at. I know that Miles gave us a directive about a week back, where for the large players like Qantas Group, we were looking to take some of the control that was held by Qantas and start to turn some of those timetables around so that we were controlling them, not so much that Qantas was controlling them. So that's a pretty quick a précis of where we're at. We do that in groups and batches. So we have a team out there, Emily and cohort, who are the legal liaisons. And as deadlines approach, we're getting the advice from them that we need to be attending meetings or not attending meetings, whether we should be sending the letters or not sending the letters. All the letters have been drafted by the legal team. We're essentially just putting in some specific details to specific airline states or roles or positions. And we'll model them, and as we model them, we'll get faster at doing that, because once we've done one for Virgin New South Wales, everybody else that's in that group becomes a lot easier to do. They're all essentially the same letter saying that we're looking to start a dispute. We're starting a dispute in regards to your enterprise agreement, and the company's not complying with the enterprise agreement. The reason we do that is because there's several clauses within your EAs that afford you further protections outside of the Workplace Health and Safety Act. So we're trying to put as many of those protections between you, your employer, and the unemployment line. I hope that makes sense. Does it make sense to you?
I think so.
Anything I need to add?
No, I think that's fine. There's a few questions that have come through. If you want to look at some of those. Yeah, might be.
What's the plan for this ride? 50 staff will be terminated according to Qantas. Also, so inevitably we're going to try avert that with this next set of letters that we say puts them on. Well, we escalate the dispute to a second level, and we call on Qantas to meet their obligation to maintain status quo until the matter is heard at the Fair Work Commission. Now, I'll further clarify that in a group email. I do believe there's also an alternative being flagged by the legal team, but before I say that I know that for sure, I'll just double check that because Miles isn't here. And if it is so, then I'll send a group email to that effect, because you're a large cohort as a rule. Exemption, Rex policy says no exemption period. What to do about that? And again, with Alliance Airlines and, which is Rex, the pilot's EA is rough, but it still maintains the primary clauses. For those who aren't pilots, the enterprise agreement has plenty of protections in there, and we've called on Rex to honour those EAs. And if we've been flagged that you're on a notice to explain why you shouldn't be terminated, that will be appearing on our list, and we'll send those letters out on each occasion. So that's a job for us to make sure your employer is getting that second notice in a timely fashion to avoid the terminations. Quick question, I need to let my manager know my back status by next Monday as we spoke on the phone. Okay. It's still simply that we're saying that you're undecided. The reason we say you're undecided is your employer is going to say that that is an unvaccinated status according to whichever mandate. The principle here is that by saying undecided, the employer makes the decision about your status, not you. So that gives us another string in our bow when we say, well, no, our member never said that they were one of the or the other, the member has actually said that they're seeking the relevant information to make a safe assessment. So that's why we continue to head down that path. That also gives us, and in plenty of the meetings and those I've done with some of you from reps will know that I take a pretty hard line in that at the meeting. There has been no refusal. There is no refusal. The members have always stated their status, and therefore they've met their obligation with you as the employer. It's really clear that the employers understand that not only do they have a duty to consult with you, the staff member, but when we told them that we represented, i.e. the industrial law firm represented you, that obligation switched to not only include you, but to include the law firm. When they don't include the law firm and they continue only to talk to you, they're outside of all the legislation and your EA, and that's essentially where we're taking the fight, because it's a lot easier to have a fight with the employer's non-compliance than it is to have a fight over the vaccine. I hope that makes sense. We're using the rules that they wrote that they're not complying with to get you the protection at court. Because the argument over the vaccine is not solid, not as solid as we'd like it to be, whereas the argument in the reverse is significantly a lot stronger. So that's why we're heading down that road, and that's why you'll see a slight pivot in our strategy. The law firms are working with a couple in Melbourne as well. So as each firm sort of goes in and takes on their own battle, the information we glean from each of those helps to decide our strategy. I need to let my manager know I've accessed on that one. Virgin Airlines, I'm taking VA, has stood us down with no pay. We may face termination if it's all those have been sent, including the stand down one. What will be next? So the next letter Virgin Australia will get, and what we've started sending out, is a dispute at level 2, in which we clearly identified the clauses of status quo, and we clearly make sure that they understand that anyone who makes the decision could be liable for civil penalties with respect to the Fair Work Act. Now, I'm going to say this, and it's probably not the most palatable thing to hear. There's either they will continue where they're at, or they'll make a Group 10 decision to terminate. If they choose to separate you from the business, that's a decision they do, knowing what the consequences will be. And at no time are we going to walk away from that. It means that we will continue to fight that, and we will continue to seek reinstatement, and we'll continue to seek compensation, and we'll continue to seek restitution of lost income, annual leave, and the rest. But at the end of the day, the employer can choose, knowing the consequences, whatever they wish to choose. And that makes no matter whether it's this issue or an issue 12 months ago or an issue 12 months in the future. At the end of the day, the employer is the employer, and they can choose whatever tablet they wish to take and force that upon you, as any good human being after that point, we need to go to a court and seek a third opinion, and that's where we'll go. But in the first instance, we're going to make sure that the employer knows as clearly and as succinctly as we can put it, that if they move away from the EA, that we're prepared to come and take that matter to the third umpire. I'm not aware that Virgin are running different timelines. I'm aware that different Virgin crew members have different dates given based on different things that have occurred. So if a Virgin crew member had applied for a medical exemption, and by the time they've assessed that, that has put some of their dates back, but the mandate date is the mandate date. So they've just been, I guess, a little bit flexible. I've seen some letters come out that say to people, you're going to apply for an office job. However, if you apply for the office job, come this date, you won't be able to go to the office. So they're sort of offering false opportunities, but at least I guess that helps them look better, but it doesn't really. The Qantas risk assessment. The Qantas risk assessment is really detailed. It's detailed to the point that no one can understand what it is. And the point of the risk assessment isn't about the risk of COVID infection on you or your risk of getting COVID. The point of the risk assessment is under whichever state you're in, all of the workplace health and safety, occupational health and safety, all have a precursor in that in the event that an employee feels that something is unsafe, an activity or a substance or whatever, the employee is lawfully allowed to remove themselves from that risk. So when we talk about a risk assessment, the reason I asked for the risk assessment initially was to put you and to give you that position within the Occupational Health and Safety Acts, as in you are lawfully allowed to remove yourself, A, because they're experimental, B, because you haven't been given the risk assessment of what the likely reaction of that vaccine on your body or on your future person. So I'm not sure how many of you have ever heard the term MSDS, or Material Safety Data Sheet. Your employer can't bring 4 litres of oil, 2 litres of oil, and there was a point in time where they couldn't bring dishwashing liquid into your workplace without an MSDS. So the MSDS clearly identifies what the substance is, how the substance is made, what chemicals are used, what the short-term risks are if you're exposed to it, what the long-term risks are if you're exposed to it, what the hierarchy of controls are if you use it, and what the first aid procedure is, and what the emergency procedure is if you have an adverse reaction. So particularly in Victoria, where they've said that the responsibility of the mandate is on the employer, it's particularly pertinent in that because of the mandate, and this is across all states, essentially only gives the employer the right to collect your status. Once they start writing policies internally that say that people have to have the vaccine, it becomes the onus of the employer. Now, all the employers are trying to shun that and go, no, it's not us, it's the government, it's the government. The government didn't make them write a policy that said you've got to have the vaccine. If they're going to have the vaccine and they're going to introduce the vaccine into the workplace, then there needs to be the MSDS and the appropriate risk assessment of the effects on you. The same as when that dishwashing liquid's used, the same as when that 4 litres of oil is brought into the workplace. That 4 litres of oil isn't assessed of its effect on the aeroplane or on the motor vehicle or on the cart or on, I'm trying to think what they call those, the tongue. They're all assessed about the effect on you. And that's what we want from Qantas and every employer that we've sought these risk assessments. Now, the Qantas risk assessment does a wonderful job of deciding whether COVID's going to have an effect on you and what the likelihood of the effect of COVID will be on their business. But it does not, and still does not, have any reflection of the risk of you taking the vaccine personally. And that's where we stand with regard to risk assessment. So until a risk assessment says we've done a risk assessment of the likelihood of AstraZeneca on Darren Dixon, no risk assessment is going to make that grade. Okay, so if you're salaried staff and you don't have an EBA, then you're going to fall within the group of people who are award free. So if you don't have an EA, the next port of call is an award. And then if you don't fit within the award, you'll fit in the award free category, but they're all designed to have very similar protections. The state and federal acts override all of them, and salaried or otherwise, you are required, or your employer is required, to comply with those acts and pieces of legislation. So don't get too concerned if you're contract or salary. The Fair Work Act, the Fair Work regs, and the Fair Work Memorandum of Explanation, and likewise for the Workplace Health and Safety Act or Occupational Health and Safety Act, depending on your state, and the regs, and likewise the same, the explanatory memorandums will pick you up, and whilst we can't initially start a dispute, the legislation will still pick that up, and we'll pick up if you're inside of an award, and the award will have those clauses because they're standard across the awards. Yep, privacy matters. Yeah, there is inadequacies across a lot of the risk assessment. And again, that's where Qantas, being so big, work in large scale and not people scale. If the Fair Work Commission and half the rest of the judiciary is corrupt, then how will any of what we're doing, trying to do, be of any benefit? Well, like any given day, we hope that the people that go to these adhere the decisions based on the evidence, do so based on the evidence. We have no control over who's elected, and we hope that they remember that they're there for the benefit of people, and society is judged by how we look after the people who are less fortunate or less resilient, or don't have the same resources, or are hurting for some reason or other, whether it be your aversion to taking vaccines, whether it be your right to choose. That's what Australia was about. And look, at the end of the day, we'll continue to fight whilst there's a fight to be had. So if we lose round one, we'll go to round two. If we lose round two, we'll go to round three. I've received 3 letters to send. However, the job title is health worker. How can we change this? Yeah, if the letter's in Word format, and you've got one of those original ones, just change it. I do believe the website itself has been updated. What we don't want, please don't wholesale change the documents. Those documents have been written and scrutineed and tested and rewritten, scrutineed and tested. So we need to keep the basics of those, well, more than the basics. We need to keep the fundamentals of those letters specifically as they are. So as we're human and we're pinching bits out of certain letters because they're the appropriate bit for that letter, rather than rewriting whole letters, if we inadvertently grab a section that says health worker, feel free to change that to your position or your role within your workplace. And I'll just apologise if we missed that. I want to use my EBA as a vehicle to include that. Hi, Rodney. Yeah, mate, that's where we're heading. Please give us the opportunity to do that on your behalf. So Rodney wants to use his EBA as a vehicle to workplace health and safety and fair work, which identifies him from disciplinary action until resolved. That's exactly where we're heading, Rodney. We're just, you know, like, it's like any good thing. The house of cards is built on a good foundation. There's a reason that we've gone through the processes we've gone. Some of them has been about, some of that has definitely been about getting some early decisions about what's tested and not. But we'll be heading, factually, we'll be heading down that road of using the workplace health and safety and fair work through your EBA as the vehicle to get to that. So please bear with us. Look, I can say it a million times, but I truly want you to believe that we are motivated by trying to get all of you guys across the line without being terminated or with as minimal harm as we can get. However, we don't need to get too premature with what we send, because the law is funny and sometimes we'll get to a point and the court will decide, for want of a better term, there has been no mitigation or no accident, for want of a better word, for us to be responding that way. So we need to make sure that we're reacting to something that occurs with your employer, not predetermining what your employer will do, because if the employer pivots, then what we've done makes us look stupid. So I know it's a great leap of faith, but you come to us for a reason. We're so conscious that we have all of your faith in our hands, and we're doing everything we can as metered and as respectful as we can. From my annual leave until 15th December, can I be termed after the 15th of November? My initial response to Vivian's question is, no, you cannot, you're on annual leave. Again, it doesn't say which state you're in, but I would definitely, if they take anything that indicates that, let us know. But annual leave, as long as you've reported your status is undecided, then you've complied with the mandate, especially if you're in Victoria and your employer has no reason to take any action against you. Yeah, if you're still getting health letters, good point, thank you, privacy matters. Navigate to the page through PDAA and you'll find that we end up on a big page that has all of the associations, and you might just need to read the fine print as to which one complies with you. So just be careful which letter you grab. I've done all the steps for a successful plus document for July. Okay, I phoned everybody. The next steps are ours, essentially. You've done all you can. Just make sure you put a ticket in if you haven't done so. Just because I want to make sure, doubly sure, but I'm pretty sure you'll be in the system and we'll just be waiting for the appropriate time to release those dispute letters to your employer. I've not heard back from VA after letter 3. They've never got back to me. And RU was included in communication. What happens next? Wait for VA next week. Yeah, essentially a lot of this is driven by VA until we start the dispute letters. Once we start the dispute letters, and you won't miss them because they're very forthright and very direct. That's where the legal team start to dictate the terms. And most of your agreements have, not all, but most have timelines in which things are to happen. And we're being very vocal about their obligation to us to consult. Yep, Red Union will represent all the members regardless of what correspondence they had or had in between. The only exceptions to those are those that are jumping in at the last minute as of now. Those members are being asked to contribute by paying for the monthly. And in some cases, if they're looking for bespoke, they're being asked to pay annually. And that's only in fairness to essentially everybody else who's been chipping in along the way and done the hard yards. So those who have chosen to jump in at the last minute and we're having to scramble to get them caught up because that's, instead of us being able to use our resources more widely, they're having to have a bespoke service. But otherwise, Red Union has stood by its promises and will continue to stand by its promises. And providing the members have followed the process, then you get the support that comes with that. If you've stepped outside of the process, then that becomes a decision for the lawyers as to how far you've stepped out of the process and whether your matter is likely to continue or whether it's likely to hurt the greater good. But they've been, thankfully, very far and few between. So don't panic. I think I'm aware of like 3 out of the 1,000. So you've got to have stepped pretty far to the left for something like that. COVID, I don't know how to deal with my spells. Okay. First of all, I hope you're okay. And I hope you're not suffering too bad. Your status will be continuing to be what it has been prior to you getting the I want to call it a flu. What do you call it?
Yeah, I think that's a mild.
Yeah. So your status will remain the same. I'm curious though, what the deal is after you get over COVID. If you have the antibodies, does that then make you exempt from the vaccine?
I don't know.
Yeah, that's a question I'll need to go ask. But it'd be handy if you've asked that question and you know the answer. If you could let us know, that'd be great. But you know, if we look at it from a purely legal perspective, they're going to say, "Have you had the vaccine?" And that may be a different fight that we have to have, particularly in your case. So we'd be interested in you providing us some more information on that one. Yep, someone's still flying, so I've been stood down without pay, but they're still paying me. My other lawyer told me to maybe just leave it alone. But he tells me to send the stand down letter if I don't. That's a problem. Yeah. Essentially, AD, that's a call for you. For us, the letter will be a problem if it's not sent. You could hope that the left hand doesn't know what the right hand's doing, and maybe they don't correlate the two. Yeah, tough call. But from our point of view, that stand down letter needs to go. Yeah, it's very important. It's super important. All of those letters go out because all of those letters show that we've made numerous attempts to remind their employer of their obligation, to seek the employer to consult with your representatives and to comply with the legislation. All of those letters have been stood out and stepped out to do exactly the process. So broader vax mandates. We've got hearings set for early in December. Currently now, it's the view that we're, apart from what injunctions are in place, it is the view that we're doing a judicial review of the mandates. So there's a belief in the lawyers groups that there's certain obligations upon the chief medical officers to have undertaken certain roles or certain tasks prior to issuing the health mandates. It's believed that they didn't meet those obligations. So the challenge that's on foot is essentially to say that the courts overturned the health mandates because the health chief health officers didn't meet their obligations under legislation. So they're all essentially being judicial reviewed. I think the first hearing's in Victoria, and then they'll be used then to build on the others. AS 2014, we will use all of them. We are strongest, I guess is the best way to put it, when we're using the Occ Health and Safety Law, the discipline laws and the Fair Work laws, because that's what we use every day. They are our strongest pursuits. That does not mean that we won't be using any others. And we've got silks and QCs and barristers all out there, all potentially great at what they do. And as we're consulting with them on a regular basis to get the best advice. And I guess we need to be focused on a few poignant subjects rather than trying to throw a shotgun effect. Because one good argument is more likely to win this matter than 50 mediocre arguments. As we've seen with some matters that haven't gone people's ways through other firms and groups. So we've really put our arguments based on our strengths, not our weaknesses, and we've looked to make them decisive and poignant to the point, so that when we go in and we have these, we're forearmed and ready to fight. We have determined the border vaccine. Yes, privacy matters. We are certainly looking at the fact that, particularly your industry, you work in federal land, not on state land, and that the federal rules are particularly more poignant to those within the aviation industry. That has not been missed. Yes, different states have different mandates. Some of them have different dates as well. We're doing our best to meet every individual's need by state and time. Yeah, and I think I've answered that one. 2014, yes. Regional staff and office. If you continue to email them towards Red Union, we're doing our best to answer all of the emails, as I know it's probably not great comfort that we can't get back to everybody as quickly as we can. We are recruiting our butts off to get people, and we are trying to get as many volunteers as we can up to speed. If you do a ticket with a specific question, that is coming through to the advocates, and we are doing our best to answer each of those individual and specific questions. I do ask you to be tolerant though, because we are also doing our best to get all the disciplinary letters out attend meetings as they're falling due for people. So there is a large list of demands upon us to be everywhere at once. So email specific questions sort of take the lower priority for us, as opposed to making sure everybody's letters are out on time and that we're supporting as many people as we can through the interview processes that go on. Sorry, I'm following. Yes, Zarif, we would agree. And it's interesting to see how many companies are writing policies to try and cover their behaviour as it stands. That will be something that's dealt with in the due course of the mock-ups that follow the initial fight. Again, we're focused on trying to save as many jobs in the first instance. Once we can say that we've saved as many jobs, then the second focus will be, well, it won't be the second focus, it'll happen at the same time. Those that we couldn't save will be fighting for, and those that follow that will be about then trying to get restitution for what was clearly a mistake in our view, if not yours. If you're on leave, you're not at work, the mandates only preclude you from attending work. So action that will taken upon you whilst you're on annual leave would fit clearly in our view to being unlawful. Is the maximum mandated type of PPE? Yeah, that's another way of putting it, Vivian, that if the mandate is a PPE, then they need to provide a risk assessment on the new PPE they have introduced. Certainly that's a clever way of turning the phrase. Thank you, Vivian. Yes, it does like detail. So privacy matters again regarding the risk assessment, having minimal data in respect to adverse events. And that's correct, it does. Yeah, look, from Rachel, the response that was received in regard to the third letter was that they do not recognise it as an industrial dispute. They said the dispute resolution only applies in relation to a dispute about matters arising under the agreement or in relation to the NES. The letter does not relate to a matter arising under the agreement. So clearly they don't understand their agreement. There hasn't been an agreement I haven't read that says when the employer decides to terminate, that either fits within the major category or it stands alone as the reason to consult with the employee's representative. So every EA has that in one way or another, and on that basis, that's clearly a basis for a dispute. They can cry all they want over it. We will certainly take that phrase to the Fair Work Commission. Well, I've had the employers just go, "Look, not us, it's not in the aircraft." Yes, the fact that I'm unable to discuss with my new doctor. I'm not sure, Kelly, why you can't discuss it with your doctor. If for some reason you think your employer can stop you from getting health advice, talk to your doctor. Your employer's clearly decided that they have more power than they think they're allowed to have. Talk to your doctor. And if they take adverse action, let us know. I've made it very clear I cannot share my disclose my wishes. Yeah, again, Rachel, you're entitled to share that risk assessment with your representatives, where your representatives, presumably you completed the letters and nominated us. You are entitled to seek advice and you are entitled to seek representation. As much as Qantas would like to think that they're above the law, that is the case where they are not. The vaccine is a control measure for the dose. Must be accurate. Yes, I agree with that comment. The comment is predominantly about coronavirus being a risk and Qantas required to do a risk assessment. Sick leave is the solution for adverse events after the vaccine. Yes, it is. However, if you're going to get the vaccine and you are sick after the vaccine, please do a risk. Please do a workers' comp claim. They'll deny it, but then it will be at least reported as such. And given that you're being mandated to have that, if you do decide, then please go to the federal government's website, find out what the compensation claims for that are, and do your best to fit within the criteria, I say. If you're going to have it and you are going to be ill from it, or you do suffer side effects from that, you may as well put yourself in the best position to claim the compensation for any adverse effects from it, or in the future. So do I, Mr. 2014 or Ms. 2014. Is there much trouble within our group since we received from the third letter, as they do not recognise the industrial state? But it doesn't matter whether they recognise or just not recognise it. The letter that says we're in stage 2, that will follow the letter you reference, clearly points out where the dispute sits within the EA, respective to your job, role, and state. And again, I would put it to let you all know that the fact that they're not prepared to acknowledge that there's a dispute puts them in a world of hurt when we get to the Fair Work Commission, because the commission doesn't work so much as in actuals, but in fairness. So if you go to your employer and you're saying, I want a dispute about something, the commission's first port of call will be, why didn't you go down this road with this employee? Because remember, the Fair Work Commission doesn't require a person to be a lawyer. It's not like heading to any of the magistrates, federal courts in your state, or council or county courts in each of your respective states, where you're required to have a law degree and be approved at the bench or the bar to be able to prosecute a case. The essential point of the Fair Work Commission was to provide an equal playing field. The Fair Work Commission was built on the fact that an employee with no legal experience can go to the Fair Work Commission and have a dispute with the employer and no legal document being there. Even if I go to the Fair Work Commission today and I'm an industrial advocate, not a lawyer, I have to seek permission to be able to represent. So the point of the employer not acknowledging the employee has made or lodged a dispute, the first point of call, the question the Fair Work Commission will argue with the employer is, well, why didn't you look to resolve the matter with the employee, regardless of whether you thought there was a dispute in regards to the agreement? And let me go further and say that because your employer says it's not, there's no different than our legal team saying it is. On occasion, we'll be protected. Yes, in regards to casuals. Thank you. You're welcome. I just hope we don't, we meet your expectations and we come out of this battered, bruised, but happy. Yes, please keep your paper trails. You know as well as I do, no job's done till the paperwork is done. Yeah, there's the airline crews, but we're representing multiple industries and each industry has its own particular quirks. What we particularly like about the aviation industry is that there are some very clever groups and very clever individuals who have been working with us to make sure we get across the intricacies within the industry and making sure that we're as equally supported to support you guys. So it would be wrong of me or remiss of me not to say thank you to those people today. Interesting, Mary. I like that. Don't lose that employment contract. I think I've mentioned that one. In respect to, I think I've sort of covered that twice. In respect to, they don't recognise the dispute. We do, they don't. That's why we have a third umpire. With regards to your accruals, i.e. sick leave, long service leave, annual leaves, if your employer is of a view that they're going to stand you down and not pay you, then our view is if you've got them, take them. Just make sure that when you put on the leave, you're saying, I'm taking this leave in view of being stood down without pay, so that we can clearly delineate you wouldn't have taken it any other way, but for the emerging need of hunger and sustaining one's family. Not that that's the only precursor. We will certainly be arguing for all of it back for everybody. But, it won't hurt to have a few of those letters in our kitty. Did mention that, and did mention that, construction as 2 months ago. But even if it mentions the vaccine, BM, the point that they mentioned the vaccine needs to be assessed not as a group, because the vaccine will have a different, potentially a different effect on every individual employee, as we all have different genetic makeups. And you can't make the presumption that different ethnicities won't have different responses, as we've seen throughout the world. So it's a presumption of great faith to go from one vaccine deals with every type of person. If that was the case, we wouldn't have seen so many different strains. That's interesting. What's that one? Don't get that one. Yeah, I wouldn't get that one. That's not. I should have been smarter and signed on with something else, not that. After the first letter coming, yeah. Again, it's that you've sent that risk assessment through. One of the team would have assessed it, and we would have either told you it was good, and we haven't seen one yet. So our instructions are to keep proceeding with the steps. I'm sorry that the sound's a bit muffled. I'm trying to speak as loudly and as clearly as I can. So my apologies for that. A couple more. Yeah, just a couple more because I need to get back to letters that I need to get out for the day. I have my own special count. Thank you. If we're aware of adverse events in the network, yes, please. If you are aware of adverse events, whilst we're monitoring the TGA's hotline, please, any supporting evidence from the people, greatly appreciated. Just the latest letter I sent was a 51. Let me, that should be in our system, Ash. If you can just make sure there's a ticket. I'll follow that up, but we should have, if you haven't had the 51, maybe you're waiting or staging point at this point. If you've had a show cause letter, then please make sure you've uploaded the show cause letter, as that triggers the next lot of letters, and those letters will come from us. Do we need to disclose the vaccine status from here onwards? If you have disclosed your vaccine status, you can stop disclosing it. However, I say that with an air of caution. If they give you a directive to report, then you need to follow the directive. I know it's stupid, however, it's a primary game that we're playing with primary rules. So a lawful direction is a lawful direction. The lawful direction is to disclose your vaccine status. if they ask for it 10 times, then rather than you get caught with the you failed to follow a lawful direction rule, then send them back an email saying my vaccine status is unchanged from when I originally reported my vaccine status. And that vaccine status is undecided or unresolved, and that's the end of the matter. They then choose to categorise you as unvaccinated in compliance with the mandate. If you're called into the office, Mary, please let us know, and we will, in the first instance, we will ask you to ensure that they know we're coming with you and that we wish to know whether they're doing it by Zoom or in person. If they're doing it in person, we have people in Victoria that can go. If they're doing it by Zoom, then the people in Victoria or one of the industrial advocates here will be a party to that Zoom. If they take the view that they want the primary answers from you, then we'll let that float for a little bit. Or you can just say, I'm not happy, I'm not comfortable with providing personal answers. I've briefed my representative and my representative will provide the responses. What's the Commission said so far? The Commission said so far not a lot, to be quite blank. To date, no one's actually got to the Commission. To date, it's all been wrangling in the federal court, which is a bit bizarre. So essentially, the fight's essentially been so much about the judicial review. We've only just last week seen any terminations. To date, we're being told by the law firms that we've been able to avoid 5,000 odd terminations to date. That being said, we've started in the last week. At the end of last week, we've started to just see terminations, and there've been terminations from weird people. So when I say weird, as in not major employers, as in from the aviation or transport industries. What we're actually seeing is groups like Reese and wire brush manufacturers or brushware companies, those sort of groups that that are not, although you might say Reese is mainstream, for groups that you wouldn't ordinarily hear from, that aren't major media focused groups, I guess.
Might have to make this one the last one.
All right, so yeah, it's like I'm running out of time, so I'll make this the last one. I hope this has helped alleviate some fears. And I'm sure that I could probably do this for 2 days and people will still have concerns. Please keep your faith. We're doing what we can. Are you able to confirm if an employer can tell us that we cannot use our sick leave, even if we have a medical certificate? Your employer cannot cannot stop you from using sick leave in the event that you have a medical certificate. That law didn't go away. If your employer decides that your medical certificate is insufficient, your employer can send you to their own physician. And if they choose to do that, then let us know. But otherwise, the Fair Work Act clearly says, and that all that's required is that the employee provides a medical certificate that a reasonable person would accept as being correct. Now, some of you might have intricacies that are given away in your EVAs that says it must state a medical condition, and that's fine. State a medical condition. But a medical certificate written by a medical practitioner, and that includes a chemist, and that includes a physio, and that includes a medical practitioner that a reasonable person would accept has the knowledge to make that decision. All right, so that's going to tie us up. We'll try to do another one in reasonable succession, so that we're keeping the aviation industry as a tight group. We do have plans in the new year to break your way into a group with your own corresponding experts. And we're looking at those who have stood out and led the groups for now in your industry. You, like us, weren't given the opportunity to prepare for this anomaly in the world's view, or where the governments, state and federal, would take it. So like you, we are doing our best to deal with what befalls us on each day. Thank you for your time. Thank you for your patience. Thank you for your understanding. We're hearing what you're telling us, and we are doing our best to try to fill those as quickly as we can.
So the recording as well, guys, will be online, I'd say, by 5 p.m. Brisbane time. That will give you a chance to go back and see anything you might have missed, or share it with any colleagues as well that maybe couldn't make it. Yeah, thanks from my end. You're all good, Darren.
Thank you all.
Thanks, guys.